Okay, I'm just going to do a brief recap of how the Supreme Court chooses and decides cases. So they get thousands and thousands and thousands of requests from people to hear their case every year, right? Up to 10,000 cases. And the way that you ask the Supreme Court to hear your case and hear your complaints is to file what's called this writ of certiorari, or you could call it a petition or a writ, anything you want. And you fill out this form and these reasons of why you think your case should be heard by the Supreme Court, and you send it in. It takes 4 Supreme Court justices to decide to hear a particular case. So they all sit around a table and they present the ones that they think they should be heard. And if 4 justices vote, then the case will be heard by the Supreme Court and considered by the Supreme Court. The next step after that is the lawyers on both sides submit what are called briefs. And briefs are extremely long papers, essentially, research paper, whatever, that lay out all of the arguments about why their case should win. And they rely on past Supreme Court cases and past federal cases to support their case. These are legal reasons why their side should be winning this case. But the lawyers for each side aren't the only ones who file these so-called briefs. There are outside groups who have an interest who will also submit briefs. This could be the American Civil Liberties Union or the Human Rights Campaign or the Society for the Protection of Animals or just other individuals or the Chamber of Commerce, a business organization, or the National Rifle Association. Whatever the issue is, there are outside groups that care about it a lot, and their lawyers also submit these briefs to convince the Supreme Court justices of why one side should win over the other. These are called amicus briefs. Amicus comes from friend. So then all of the justices and their clerks, the people who work for them, read those briefs and all of the arguments on one side or the other before they even go into the Supreme Court chambers. Then the next step is what's called oral argument, and this is where the lawyers for each side actually argue the case in front of the Supreme Court justices. And they have a limited amount of time to present their case, and the justices ask them questions and try to ask about weaknesses in the case or have them explain their decisions further. This is called oral argument. Then after that, the Supreme Court justices that same week will meet only amongst themselves, nobody else, just the 9 justices. They meet on Wednesdays and Fridays in a room. They sit around this conference table and they discuss the cases that they heard that week. And this is where Justice Roberts was saying everybody has a chance to speak at least once in a row, and then they go around and around and they you get an indication of where the justices are, which side that they're on, and they take a preliminary vote, and then they are one person on each side. If it's unanimous, then one person is assigned to write the opinion, and if it's not, then there's an opinion, a majority opinion, and a dissenting opinion. And then that's the final step, which is writing these opinions. And the opinion is why we agree with one side. What is our reasoning about why we're supporting the arguments of one side over the other? And the very, very, very important thing about these opinions is other lawyers in the future rely on the reasoning of the justices in the opinion to support future decisions and future arguments in cases. So there is one opinion, the majority opinion, that creates what is called precedent, that sets the law and the reasoning for future policies and laws and decisions. And after the opinion has been written, the justices come back and they're all together and they announce it to the public.